Ready, start. Once the state has formulated its policy defining the terms for premature release, due consideration in terms of the policy must be given to all eligible convicts, full stop. The constitutional guarantees against arbitrary treatment and of the right to secure life and personal liberty must not be foreclosed by an unfair process of considering applications for premature release in terms of the policy. Full stop. Significantly, the policy has been amended to remove the requirement of convicts submitting an application for premature release and instead places the responsibility on the officers of the state to consider eligible prisoners. Full stop. The prison administration, the legal services authorities at the district and the state level, and officers of the police department and the state must diligently ensure that cases of eligible prisoners are considered on the basis of policy parameters. Full stop. We have gained a distinct impression, based on the cases which have come before the court here and even earlier, that there is a general apathy towards ensuring that the rights which have been made available to convicts who have served out their sentences in terms of the policy are realized. Full stop. This results in the deprivation of liberty of those who are entitled to be released. Full stop. They languish in overcrowded jails. Full stop. Their poverty, illiteracy, and disabilities occasioned by long years of incarceration are compounded by the absence of supportive social and legal structures. Full stop. The promise of equality in our constitution would not be fulfilled if liberty were to be conditional on an individual's resources, which unfortunately many of these cases provide hard evidence of. Full stop. This situation must change, and hence this court has had to step in. Full stop. We now proceed to formulate peremptory directions. Full stop. When a state government or a union territory has adopted a policy for the grant of permanent remission which incorporates conditions for eligibility, it becomes an obligation of the state government or the union territory to consider cases of all eligible convicts for the grant of permanent remission as per the policy adopted. Full stop. If such a policy exists, and if the state government or the government of union territory raises a contention that relief will be granted only to those who apply as per policy, it will amount to saying that even if convicts are eligible for consideration in terms of the policies, their cases will not be considered in terms of the policy. Full stop. Such conduct on the part of the states will be discriminatory and arbitrary and amount to a violation of Article 14 of the Constitution. Full stop. The power under Section 432 within bracket 1 must be exercised in a fair and reasonable manner. Full stop. Therefore, whenever there is a policy for consideration of cases for permanent remission, it becomes an obligation of the state to consider cases of every eligible convict under the policy. Full stop. It is thus apparent that after the preparation of a list of all life convicts and other convicts who will be entitled to be considered for premature release, the said list must be regularly forwarded by the prison superintendents to the appropriate government so that the case of premature release of such convicts is considered by the appropriate government. Full stop. Since we are on the SOP made by the NALSA, we may note here specifically that the SOP provides for appointing an advocate for the purposes of challenging the order refusing to grant permanent remission. Full stop. We request NALSA to consider incorporating in the SOP the requirement of bringing to the notice of the convict the fact that the convicts have the liberty to challenge the order of rejection of grant of premature release. Full stop. The power under section 432 of the CRPC is to be exercised in a fair and reasonable manner. Full stop. If there is neither a policy nor any regulations for exercising the power under section 432 of the CRPC, there is a possibility that the authorities will not exercise their power in a fair and rational manner. Full stop. To ensure that the power is not exercised in an arbitrary manner, all the states that do not have an exhaustive policy on this aspect must come up with an exhaustive policy within 2 months from today. Full stop. It can be either a separate policy or it can be incorporated into the prison manuals. Full stop.